Let's talk about testamentary trusts. What are they, and are they court supervised? Well, a testamentary trust is a trust that is created by someone's last will and testament. So what that means is that this is a trust that is created by a will. A will has no effect until there is a death. So this trust is not going to come into place until somebody has died and then their will is probated. And then these trusts, this testamentary trust, is created. What kind of trust can be a testamentary trust? It could be a trust that a parent creates for a minor. Remember, if you have minor children, you are going to want to have a will that nominates who would be the guardian of your children. And then your will create a trust for your children. A testamentary trust can be what we call an asset protection trust, protecting assets against any sorts of creditors, long-term care costs, government benefits eligibility purposes, for example, Medicaid long-term care or any other kind of needs-based benefits. That is a asset protection supplemental needs trust. In Washington state, those have to be created through a will if it is for the benefit of a surviving spouse. Otherwise, Washington won't honor it with regard to long-term care costs. Other testamentary trusts are tax protection trusts. That could be what we call a bypass trust. In Washington, our credit exclusion amount for estate tax is $2.193 million. The federal level is far higher at $12.06 million. So if you live in Washington, you are married, you likely are going to want to have a bypass trust in your will so that when the first spouse dies, their credit exclusion amount is captured and taken advantage of. So for example, if you have a $4 million estate, first spouse dies, we want that first $2 million to go into this trust. If you don't do that and the surviving spouse is left with $4 million and then they die, well, they're going to have to pay hundreds of thousands of dollars in unnecessary estate taxes in Washington. So a bypass trust created by a will can avoid that. Other types of trusts, there's grandchildren's trusts that can be put in a will. Now, there is some misconception. Sometimes people think that since a will must be probated, that means that these trusts thereafter are court supervised. They are not. Once these trusts are created through the probate process, then the trustee will carry forth with their duties of properly administering the trust, but there is not court supervision or intervention of the trusts. You may have gotten concerned when I said that the will that creates the testamentary trusts, and even though the trusts aren't court supervised, you heard me say that the will must be probated. That is true. A will must be probated in order for it to take effect, for anything that the will says to happen will happen, including creating these trusts. Now, I'm talking about Washington state right now. In Washington state, when the estate is a solvent one, meaning there's more assets than debts, it is what we call a non-intervention probate. What that means is that the court is not involved at all with the probate process. And because of that, it is a very simple process. Yes, there's statutory rules that have to be followed. That's why you want a lawyer to do it. And there will be legal fees, but the court isn't involved giving permission to do this and to do that. You can sell the house, you can do all sorts of things, and the court does not have to be involved. And because the court's not involved, it is not an expensive process. What do I mean by not expensive? Well, if you are familiar with, you've talked to your financial planner, or you're out of state, you're not in Washington, you're not in Idaho, maybe you're from California or another state where probates are based on the size of the estate, you have probably heard that probates can cost tens, if not hundreds of thousands of dollars, and that may well be true. That's not the case in Washington. In Washington, our probates generally will be in the range of $5,000 to $10,000, give or take, on either side of that. But that is to give you an idea of what you might expect for a probate in Washington. So why would you want to do a probate? Why would you not want to try another route, such as a revocable living trust route? Because when you have a probate, when you have a will, you likely are going to have a lawyer involved, and they're going to help you make sure that things are done correctly. So let's say you are a couple and you have a $4 million estate. And let's say that maybe your financial advisor suggested you should use a revocable living trust rather than a will and avoid probate altogether. The problem is when the first spouse dies, they likely won't know or won't understand that they need to take steps to make sure that the first spouse's credit exclusion amount is preserved. And so they don't do what they're supposed to do because they didn't have to go see a lawyer. Maybe they saw the financial advisor, but keep in mind, financial advisors are not estate planning attorneys. I'm an estate planning attorney. I am not a financial advisor, and I would not give financial advice. That's outside of my realm of expertise. Similarly, a financial planner is not an estate planning lawyer, and they're going to defer to an estate planning lawyer for what's the best plan. Getting back to the problem of having a revocable living trust, first spouse dies and no help is received for what to do next, the surviving spouse didn't know what to do. And so they didn't set up what the appropriate trusts were, the bypass trusts, and they didn't do what they needed to do to protect themselves against an estate tax. So let's say it's a $4 million, a 4.1, 4.2 million estate, and then they die. Under Washington's current rules in 2022, they are going to owe, their estate will owe an estate tax of $240,000, all because somehow they thought that a revocable living trust would be better, but they didn't understand all the work that would be needed to administer it correctly. So as an estate planning and elder law attorney in Washington, I have to tell you, we prefer using wills over revocable living trusts for a lot of reasons. One of those reasons has to do with the risks. If a revocable living trust, which could be a perfectly fine one, it could be funded correctly, everything is done right, but if the clients don't do what is needed on the death of the first spouse, what's going to happen is they may end up paying almost $250,000 in unnecessary taxes. So rather than have that risk, I'm more likely to recommend that the couple have a will-based platform of their estate plan. And yes, maybe they will pay $10,000 in probate on the death of the first spouse. But because it's done correctly, we know that on the death of the second spouse, they won't be paying $250,000. That's one of the reasons that in Washington state, we likely will recommend a will-based platform.